Good afternoon. Thank you, everyone who is joining this talk to hear about California's CARE Act. I feel before I introduce myself, I should explain why I'm talking about politics at a mental health conference about psychosis. And I think the answer to that will become more clear as this presentation goes on. But to preface it, California is going through some extreme changes in its mental health policy and laws, the biggest inarguably since the late 1960s, when California deinstitutionalized ahead of even the O'Connor decision. And these massive changes this time around are not being driven by the internal actions of the system, like deinstitutionalization was a response to the horrors of institutionalization. CARE Court and the changes, the massive changes to California policy, instead this time are being driven by California's homelessness crisis. And as such, these policies have become inescapably politicized. So with that introduction, I will let you know who I am. My name's Claire Courtwright. I'm the policy director for Cal Voices in Sacramento, California. Cal Voices is California's oldest peer-run organization, and I'm sure people are familiar with the lingo, but peer-run refers to an organization that is run by and for people with mental illness. I'm a person with lived experience of serious mental illness. I spent a great deal of time sick, and when I got well, most of my professional experience has been in the public mental health system, either as a peer provider in various residential outpatient settings, or I did a great deal of defense of folks on involuntary holds or facing involuntary medication petitions. In our mental hospitals, I've also worked in a couple of jails. And then most recently, I've worked on state level legislation in Sacramento. So I've been deeply involved in bills over the last legislative cycle, particularly. CARE Court came out of the 2022 session, so it's slightly older, but I was involved in the CARE Act as well. So since I'm talking to people outside of California, which is a little abnormal to be talking about CARE Court, if anyone has heard anything about it outside of California, it's that it's this new thing. If you're in the peer community, if you're in the mental health community, it is a bad thing. So I think the two questions that I get most often is, what the heck is CARE Court? And is CARE Court coming to my state too? So to answer the first one, CARE Court is a civil outpatient commitment schema. So rather than having a court place you under an arrangement that allows you to be placed in a locked facility, like an involuntary hold or a conservatorship, civil outpatient commitment is a court order that orders you to engage in treatment while you're not in a locked facility. So the CARE Act is a civil commitment, outpatient commitment schema, similar to assisted outpatient treatment. Most people are familiar with that. AOT has sort of become a thing across the country after Kendra's law in New York. California actually has an AOT statute in addition to CARE Court called Laura's Law. And so in trying to explain to people, is CARE Court new? What's new about it? Is it likely to spread? One of the ways that to understand it is in distinction to AOT generally. What's different about this? What are we doing that's different? And as you look at that, then you see that what's really unique about CARE Court is kind of California specific. It's really a policy that is responding to some very California specific circumstances, funding, the structure of how things work in California. But it is also, sort of a net expansion of the conservatorship, hospitalization, institutionalization system. And it's a response to houselessness. And because of those last two, it is at risk of being replicated in other states, depending on whether it's seen as successful for whatever it is that it is trying to achieve. And so again, this is heavily care court and the expansion of conservatorships that happened last year, including expanding them to SUD only, is really heavily a politicized response to California's homelessness crisis. And so therefore, whether it will be viewed as a success will be partially through that lens. So first, I just want to contextualize the homelessness issue in California, because unless you understand what we know and what we don't know and what's happening, you can't fully understand what's happening with care court. So first of all, to bust a myth, homelessness in California has been massive for decades. This is some of the older data, point in time count, where once a year people go out, look around, say, do you look homeless, and put down a tally mark. And that's where we come up with the idea of how many unhoused people there are. And as you can see, back in 2007, we had 140,000 unhoused people in California. And we had less than that just prior to the pandemic. And then going into 2019, it ticks back up. And then over the pandemic, it explodes. And then now we have somewhere, this chart's a little old, now we have somewhere on the order of 175, 180,000 unhoused people, 70% unsheltered. And unsurprisingly, over the same period of time, what do you see? You see the median home prices just explode. This is an example in Sacramento where I live. Just over the pandemic, rents up 25%. Inflation is on fire. Income inequality in California is at an absolute record. It's off the charts. And homelessness explodes. So it's really clear based on, the data that we do have that this unhoused population, the growth in it, was due to the pandemic. It was due to inflation. It was due to the cumulative effect of housing policy nationally and in California. And then for our folks with serious mental illness, the folks that are characterized as being the persons who are going to end up in care court, folks with unremittent schizophrenia, spectrum disorders that are recalcitrant in treatment. Of course, for those folks in this economic situation in California, there's nothing, right? There is no social safety net in California for disabled people, whether that disability be a serious mental illness or a serious physical illness. I think most people are familiar, but it bears repeating because folks outside of this community sometimes don't know that the only permanent income replacement assistance for people with disabilities is out of the federal system. If you don't have a work history, it's SSDI. That's capped at $914 a month. The state of California will kick in a supplement for some people of $219 a month. There's absolutely no way for a person to be housed in the state of California on that kind of income. Group housing was what had happened in the past. We had boarding care homes. As inflation rose, because those were never profitable and they were typically small and privatized entities, they began to close. The state did not do anything in response. So this is the situation. Folks have no income, they have no entitlement to housing, and they don't have what they had in the past in terms of structure for housing, which was mostly boarding care homes. So in this context, someone finally tried to ask a little bit more about the unhoused population after 30 years. UCSF, which is the University of California, San Francisco, did a study of the unhoused. And again, this is survey data based on a limited number of thousands of people, and they're projecting it onto the whole population. But what we do know about the unhoused in California is that we're not seeing that homelessness is primarily driven by mental illness or even substance use. It is all kinds of folks for all kinds of reasons. Increasingly, it's seniors on fixed incomes who cannot keep up and are falling out at the bottom. So when you're looking at the unhoused population, you may be looking at, you have to use different measures, but some of them that I think are surprising is, in this survey data, they found only 5% of the population, which implies about 8,500 people out of 174,000 had a mental hospitalization in the last 6 months. Only 12% reported psychosis, and you don't know if that's substance-induced, medical condition-induced, or SMI. So you're still not looking at large percentages of this unhoused population that actually meet the criteria that the state is saying would indicate having all these new pro-force laws. And again, this is why I'm going to say that care court is highly politicized, right? Because it's based on anecdotes and negative stereotypes and not data. The data says we just don't have a population that is all that large that is mentally ill and unhoused, at least according to this survey. So another policy context for care court is California's big. And there is a fight between California and its counties over who is responsible for people with serious mental illness. Again, there's no state level entitlement to housing or services. For our intellectually and developmentally disabled folks, we do have the Lanterman Disability Services Act. So that comes out of our general fund. It's about $14 billion a year. It's for specialized services and an entire infrastructure called the regional system to support the delivery of those services. If you look at what exists for mental health, there's almost no funding for serious mental illness out of California's general fund. And most of the funding that is there is to be used as a match for Medi-Cal services. So serious mental illness just doesn't have any kind of funding support from the state behind it that other disabilities enjoy. And California is very large. We have 58 counties. We have big counties, small counties, rural, heavily urban. And because of the need to administer state programs at the county level, the state relies on the counties and delegates to the counties to administer many things, including Medi-Cal. So what has sort of arisen from the fact that California relies on the counties to administer Medi-Cal and many other things is that there is a long-standing fight between the state and the counties over who has to pay for things. And if it is a quote-unquote state-mandated local program, then the counties get funding from the state. If the counties are just doing something of their own accord, they don't get any funding from the state. And in California, if you have serious mental illness, you're in what's called specialty mental health, and you're the responsibility of the counties as your service provider. They're administering Medi-Cal. Counties also don't have the budgets that they have in many other places because they primarily rely on property tax, and we have a strict cap on the increase in property tax in California that without which things would be interesting. It's very controversial. It's called Prop 13, but counties just don't have the budgets that they had back when deinstitutionalization happened. And obviously courts are courts of limited jurisdiction. So a court's sort of reach, its ability to order is geographically limited to a county. So all of those things combine to mean what? When you've got folks in a court-ordered system, like a conservatorship, like they're in the county jail, like they're a specialty mental health client of the county in specialty mental health services for Medi-Cal, the county is kind of the guardian. You know, in the case of conservatorships, it's the public guardian, it's the county. And the state really doesn't want to fund care for these folks, and the counties don't like it, and they don't want to fund care for these folks either. So in this context, the state blames the counties for homelessness and for supposedly falling down on its job with respect to involuntary treatment. They feel they don't conserve enough people. They feel that they're not doing enough regarding homelessness. They're not cleaning up their encampments. So there is a big blame game where the state points at the counties and saying, you're not doing a good job. And the counties point at the state and say, where's our money? So that's part of the context in which this new assisted outpatient, when we already have assisted outpatient, this duplicative system comes online. It's really to deal with this fight. So, you know, someone asked me, and I don't recall who it was now, but it was someone from out of state. And they said, well, isn't care court just AOT? And I said, well, yes, it is a duplicative system in many ways. And so if you look at how they differ, then you'll see that it's really a political thing in California. It's also a bad thing. It's worse than AOT in many ways. But also the likelihood that this gets replicated across the country, again, is sort of murky because care court is redundant. Care court is like AOT. And is anybody else really going to go down this path unless the CARE Act and care court present something that is appealing for non-California jurisdictions, non-California states that don't have identical setups to California. So just like to briefly go over what AOT is in California here, it's called Laura's Law. It was modeled on Kendra's Law in New York. Obviously, Kendra's Law in New York did sort of spread across the country, and you do have AOT in many jurisdictions. So it's basically a person with serious mental illness who has a history of treatment noncompliance, and either they were hospitalized twice in the last 3 years, or they had one act of serious violence in the last 4 years, and they're refusing treatment, and either they're unlikely to survive safely in freedom and they're getting worse, they're deteriorating, or AOT is necessary to prevent a relapse that would result in an involuntary hospitalization. So AOT really across the country was it was political also. It was based on perceived threats of violence from people with untreated mental illness. And so AOT is really a political and politicized response to that. But as you can see, they made it broader, right? You don't actually have to have an act of violence. You could just have 2 involuntary hospitalizations in the last 3 years. Refusing treatment and the other 2 alternative criteria, those aren't difficult to meet. So really, there's a lot of folks that could potentially be covered by AOT. AOT, there was no private petitioner right. So like if the family wanted you to be in AOT, you had to go ask the county, and then the county would make the decision about whether you seemed like you need to be in AOT, and then they would pursue that court case because it is a court case. AOT orders last 6 months initially, and they can be extended, and there's not really a hard limit the number of times they can extend it. And AOT also spelled out kind of treatment entitlements. So it's like, if you're going to be in AOT, you have a right to certain kinds of treatment. You didn't have a right to housing, but housing was something that they expected to try to find for you. The county is expected to try to find for you. But again, because of this funding fight and what may or may not be funded in the county, housing was not a guarantee in AOT, and AOT was never meant to specifically address homelessness. But AOT does have an entitlement to certain kinds of services while you're under the court orders, which is important. And originally, the law said that the counties could do it if they wanted to, and they didn't have to. So it was a county opt-in. And then the state said the county's not doing it. So they changed it to make it an explicit county opt-out. And about half the counties in California are now opted in and doing AOT. And AOT has been around a long time. I think it started maybe in 2003 in California. So it's a law that's been around. And, this is a recent report from 2022. You can see there's not a ton of people in AOT. The actual court order, you have to be refusing voluntary treatment. So if they approach you and you accept voluntary treatment, you cannot be in AOT. So you can see when they actually approach people and offer them services, overwhelmingly people accept voluntary services. And very few court orders have resulted. And this is in about, 20 counties. So that's about, it's not half our counties, but it's close to half our counties. So AOT really is a small system compared to the involuntary system where, I think we may have had 150,000 5150s. We're about to get real data in just a couple of days because they never made the state keep track. The state hospital system serves about 12,000 people a year. So these outpatient, like AOT as it exists, it's small. It didn't make a big splash. And yet it's broad enough that if your real concern is folks with schizophrenia spectrum disorders that are untreated, that are cycling in emergency rooms and jails, the stereotype that is held up, you had AOT. Why did you need care court? So why did you need care court? Care court basically dropped all the standards lower. And it also has a specific relationship to the conservatorship involuntary hospitalization institutionalization system. So care court you have to be an adult, you have to have a schizophrenia spectrum diagnosis, you have to be not clinically stabilized in ongoing voluntary treatment, which judicial counsel says this applies to a person who is currently engaged in voluntary treatment, but the petitioner feels they're not optimally stabilized. So you can see how low that standard is. Why should you be in court if you're accepting voluntary treatment? And then the other two prongs, the other two alternative prongs are exactly the same as AOT. So really, a care court standard is so mushy that it doesn't really amount to much more than you're 18, you have a schizophrenia spectrum diagnosis, and we think you're not clinically stabilized, which again probably just sort of reduces to you have schizophrenia spectrum disorder. So now you can be in this court-ordered system. So what can the court order? The court can order a care plan, which involves unspecified treatment, stabilizing medications, and a housing plan. The care plan is when the court orders it against your will. A care agreement is when you sort of plea. It's like a plea deal, and you agree to be under this court supervised treatment. And then there's actual voluntary treatment where there's very early on in the process, if they're convinced that you're really going to engage in voluntary treatment, the whole thing can go away. Care court orders last for a year. They're renewable one time, so they last for a maximum of 2 years. And then there's a thing called graduation plans, but that's not really still being in care court. So I think, and again, we're in the same situation where the court is able to order a housing plan, but because the counties were not given funding to house people, they couldn't require the counties to house people. So there is no housing entitlement in care court. You are not entitled to housing. More concerningly, care court is being interpreted by some of the judges in different jurisdictions to mean the court can order you to live in a clinical treatment facility. We have residential clinical treatment facilities in California that are long-term or indefinite term, like mental health rehabilitation centers. So one of the real civil rights concerns about care court is, should the government really be able to tell you where you can live for 2 years based on a legal standard that is so low that it says you have schizophrenia and you're not optimally stabilized? That's a good question. It's also a real rollback because typically if the court was going to order you to live somewhere, you needed to meet the higher standard of a conservatorship. And just the fuzziness is a real civil rights concern, right? Because what can the court order? Just about anything. And even if it's not reasonable as treatment. So the complete lack of definition or even an idea about what mental health treatment means in care court is one of the ways in which I think people can understand that it is a politicized law. If we were really improving mental health treatment, if we were really trying to improve quote unquote outcomes, if we were really trying to house people, this law would look different. This law would have been based on some kind of data. It would have been based on some kind of analysis. It would have more closely targeted the persons that were supposedly being failed by the existing system. It would have created a housing entitlement. It would have come with funding. It didn't do any of those things. It also, unlike AOT, it comes with different penalties for not following your care plan. If you do not follow your care plan, you can either be, the judge can send you to a mental hospital for an evaluation as to whether you meet involuntary hold criteria if they feel that you do. But obviously that could be abused, right? And then it also creates a legal presumption, which is basically, it is a direction to a person who is a fact finder in a case to treat evidence a certain way. So if a person scofflaws in care court and they're failed out of care court by the court and they're subsequently facing a conservatorship hearing, the judge gets to tell the jury, if it's a jury trial, okay, jury, they scofflawed in care court, and you must take that as evidence that they need something more than care court. They need further support. So there's a penalty where it will funnel people up into conservatorship. So again, this is just a little bit of a recap, but care court versus AOT, what's the difference? It's a broader, lower standard. It has a longer initial term. It's explicitly ordering someone into housing potentially, including clinical treatment facilities, but there is no entitlement for the client to housing. It also has private petitioners and a substitute petitioner process. This is also a very politicized thing and a reason why it's different from AOT. In care court, private petitioners, a family can initiate the petition, and then the court, if they make it through the front door with their papers in order, the court substitutes out the family for the county, and the county must continue the prosecution. So again, this is about the state-county fight, and state feeling like the counties didn't do enough about homelessness. So one of the things that's weird about care court is essentially the state is, through the substitute petitioner process, forcing counties to prosecute certain people in care court. Also, the motive is different. The political motive is different. Again, unlike AOT, you're not entitled to any specific services in care court. You're not entitled to housing. But the CARE Act order also binds the counties. So again, this is about the state-county fight. So when the judge issues that order and says, okay, you have to see your psychiatrist once a week, that order also goes to the county and says you have to provide this person with a psychiatrist to see once a week. That could be a good thing from the perspective of some parties, perhaps. But again, it's a difference from AOT, but it's completely political and unique to California. Also, AOT and care court, you can't do forced medication, but there are different penalties for non-compliance, including with your medications in care court, as explained, which is they can send you right to a mental hospital, or they can use it as evidence that you need a conservatorship. I will also address some of the political salesmanship about care court and why it's not what people say it is, which also speaks to whether or not you might see it replicated in your state, which is that people sort of sold care court as the nicer, softer, upstream alternative to conservatorship. That is not what it is legally. And why I say that is that the criteria to be in care court and the criteria to be in a hospital or conserved are totally different. They're apples and oranges. A person is meeting care court criteria when they may never have been hospitalized and when they are not currently meeting criteria to be hospitalized or criteria to be conserved in California. So what care court really does and why it's different from AOT and why it may be replicated and why it's dangerous is that it sits on both sides of the middle portion of the system, which is involuntary hospitalizations, conservatorships, institutionalization, and locked facility. Care court gets you first. Before you meet criteria to be in that middle part of the system, you scofflaw in care court, funnels you up into conservatorship. When you no longer meet criteria to be in a conservatorship because you're doing better, the conservator can refer you back into care court. So essentially, the court can have you longer, and the court can have you in a repetitive cycle that never ends. And that's one of the reasons that the CARE Act has really been missold as an alternative to conservatorship. That's not how it functions legally, and that's not where it sits with respect to the rest of the system. So I think, the danger of care court is that it can create a cycle that does not stop, where a person is basically continuously under a form of court order of one kind or another. And now everybody wants to know how it's going and what is actually happening in California since the care court was live in California January 1, so about 6 months ago, in only 8 counties. It is going to be implemented in all counties come January 1, 2025. And already we're seeing care court not be what it was advertised to be. First of all, because the public was sold this idea that there are a very large number of unhoused people with schizophrenia, spectrum disorders, menacing the streets and refusing treatment. And if you only force them into treatment, they will magically become housed. But what we've seen, so the state said anticipate 7,000 to 12,000 petitions in the first year. What we've actually seen to date from the counties is 323 petitions, and about 25% of those were kicked out at the most basic stage because the person just didn't meet criteria even in the lowest phase. Some courts are not kicking those petitions out. They're saying go ahead and try again. So we may have even more petitions that don't even meet the initial criteria. And the experience of the counties that have reported back is kind of similar to AOT, that actually when you offer people voluntary services, they accept them. Now, the care agreement, the sort of plea deal, settlement agreement version of a care plan, that's clearly coerced, right? Because if you don't agree to it, they'll continue prosecuting you and trying to get a care plan. But nevertheless, what we're seeing is just this way lower number of petitions than was advertised. We're seeing far more people accept voluntary and truly voluntary services than we were told would happen. We're not sure anyone has been permanently housed through care court. Obviously, care court orders last 2 years, but it could be an entree, right? You could get somewhere to live, and then that funding could somehow miraculously continue. And it's been very what treatment is being ordered is all over the map. I went and listened to some folks doing defense in San Francisco County. And they said, our client agreed to talk to the homeless outreach people when they come by once a week. That's the care agreement. So with this complete lack of structure or understanding of what treatment means, you're not necessarily going to, quote unquote, see results. And you're certainly not going to see a reduction in homelessness unless this thing trends very carceral, unless California builds a bunch of unlocked, quasi-institutionalized settings where folks can be placed by the court, sort of long-term, even though the door's not locked. You're not going to see a visible reduction in the homeless population, and care court may well be viewed as a failure or unsatisfactory as a result of kind of being upsold by politicians. And that might be a reason it's not replicated across the country. It's also just enormously expensive on an administrative side. They're spending $290 million a year for court and administrative costs, and care court came with $0 for services or housing. California is also in a budget crisis and facing many funding cuts. So the early reports is care court is not being viewed as a successful program. Even if you adjust your idea about what is successful, it's sort of being, on the one hand, revealed as heavy-handed for the folks that are perfectly willing to engage in a service you're offering them, and they simply hadn't experienced any engagement or outreach. It's being viewed as inadequate by some folks whose, children have been court ordered and they're still ending up in jail. And it's being viewed as administratively heavy on the expense without much to show for it. A reporter acquaintance from Stanislaus County told me, look, we've had 12 care court petitions and we employed 15 people to make that happen. So, whether care court survives will be a question to watch. So I'm somewhat repeating myself here, but I will wrap it up. Will care court be viewed as a success and therefore replicated? Is it going to have a major impact on homelessness in California? No, because most of the unhoused do not have schizophrenia spectrum disorders. And if they do, that is not the reason that they are unhoused. They're unhoused because they need resources. They need an entitlement. They need a source of funding for their housing. But in order for it to appear to be effective and visibly reduce some of the unhoused people on the street, it has to tend very carceral. It has to try to funnel people into the locked system and disappear them that way, or it has to try to hold them in a sort of, clinical treatment facility type setting where they can be surveilled and supervised and penalized if they step out of line. Right now, it's not being viewed as a success in California purely based on the low number of petitions, but that creates a perverse incentive to go find people you can put into care court, which is I've already heard of this happening, where folks are like, can I refer my conservatee down into care court when the conservatorship's ending? Will it result in a reduction of conservatorships? Not likely. It was designed to increase them or funnel people up into conservatorships, so it's unlikely. And anytime you have a net expansion where care court doesn't say, it's care court or conservatorship, they don't exist as a trade-off. And anytime I've seen that happen in California, like we had a 30-day hold that was supposed to be a trade-off for a temporary conservatorship that can last 30 days to 6 months. And when they instituted both without any requirement that they trade off, you just saw a massive net expansion. We were told, oh, you're going to see 45 30-day holds. We saw 300, right? So it's probably not going to reduce conservatorships and be viewed as a failure for that reason. If everybody's consenting and they're not actually having to heavily use the court process, it's going to be viewed as a failure, because why did we need a court system for this? If there's loss of services funding to the counties, or loss of the funds that they use to hopefully house people, there's just nothing there to support care court or these care plans. Client trajectory after care court, that also could affect things. If people leave care court and then it's, sort of right back to cycling in the system, care court is not going to be looked at as successful. We expect racial disparate impacts. It's going to draw some scrutiny from that because of the selection of schizophrenia spectrum diagnosis. It's massively expensive on an administrative side. But, unlocked, permanent, quasi-institutionalization, where you trade a person up and down in the court system between care court and conservatorship and care court and conservatorship, so that you can essentially court order their whereabouts, specifically with respect to where they live, that could be attractive to states but that's not about treatment. That's a system of social control. But arguably, that's what care court is. Thank you so much for attending. I think I'm over time. I hope that you enjoyed the session and learned something from it.